Namaste and welcome to Bharat Manthan, where we churn through complex issues and extract clarity from chaos. Today's episode is about a rare constitutional move that makes headlines across the section. The presidential reference to the Supreme Court under Article 143 of the Constitution. Let's understand what it is, why it happened, and why it could impact every Indian state in the future. So, what is a presidential reference? Let's start with the basics. Under Article 143 of the Indian Constitution, the President of India has the power to refer questions of law or public importance to the Supreme Court for its advisory opinion. This is called a presidential reference and it's rarely used. Since 1950, it's happened only a few times. In the Berubari case, the Ayodhya land dispute, and the Kaveri water issue. But now, in 2025, President Draupadi Murmu has used this power again, amid a brewing constitutional crisis between the governors and state governments. So, what was the trigger? Tamil Nadu versus the governor. The story begins with a major Supreme Court judgment in April 2024. In the case, State of Tamil Nadu versus Governor of Tamil Nadu. The Tamil Nadu government accused its governor of deliberately delaying assent to several bills passed by the state legislature, some of which were pending for over a year. Now, the Supreme Court made a strong observation and it ruled that governors cannot delay decisions on bill indefinitely. The words as soon as possible in Article 200 must mean within a reasonable time frame, ideally within 3 months. And if the governor doesn't act, the matter should go to the president, who too must act without unnecessary delay under Article 201. Now, the judgment was seen as a win for federalism, but it also raised serious questions about the limits of judicial power. What has the president asked to the court? So, in May 2025, President Draupadi Murmu formally referred 14 key questions to the Supreme Court. These questions include: can the court set deadlines for the governor or president to act on state bills? Does such a judicial action violate the principles of separation of powers? Can Article 142, which gives the court broad powers to do complete justice, be applied to control constitutional offices like the governor? This is the first time in decades that such a sensitive constitutional deadlock has led to a formal presidential reference. But why this matters across India? The issue is much bigger than Tamil Nadu. States like Kerala, Punjab, Telangana, and West Bengal have also raised concerns about governors blocking or delaying state bills, often in politically sensitive cases. If the court sides with Tamil Nadu judgment and permits timelines, it would strengthen the hands of elected state governments and reduce governors' overreach. But if it rules in favor of unrestricted discretion, it could lead to more central interference in state matters. In other words, the judgment could redefine center state relations in India. Now, what can be the legal and political impact of this case? So, legal experts are divided over this. Some argue that the Supreme Court has right to intervene because inaction by governors can paralyze democracy at the state level. Others warn that the judiciary should not control the timelines of constitutional functionaries, as this could lead to an overreach of judicial power. Politically, this issue has galvanized the opposition. They see it as an opportunity to push back against central interference and demand greater autonomy for states. So, where do we stand today? The Supreme Court is yet to give its opinion, but the debate it has triggered is crucial for the future of India's federal structure, constitutional balance, and democratic integrity. At Bharat Manthan, we'll keep bringing you grounded, clear, and unbiased insights into such critical issues. If you find this episode useful, don't forget to like, share, and subscribe. Until next time, Stay curious, stay informed. Jai Hind.